Yes. Yes, start.
Okay. Good morning, everybody. I am Manoj Kumar Chaudhary, Advocate, Supreme Court of India. Welcome you all on behalf of Nani Palkhivala National Law Club. The main mission of this law club is to reach last mile of the citizen. Presently, we are running 3 programs. The Legal Camp, which provides the legal advice to anybody in India free of cost. The second program is to know the insight of the AOR exam, which is this particular program. And the third is jurisprudence of Supreme Court in last decades, where we discusses different how the case is evolving in the Supreme Court. To interact with this AOR program, we have Mr. Jayprakash Somani, Advocate, Supreme Court of India, and a director of this law club. He has written more than 60 books in the case laws of Supreme Court and 3 books especially for the AOR exam. All the books are available on the Amazon and Flipkart. So from here, over to you, sir.
Thank you. Thank you, Manoj. Manoj is practicing lawyer in Supreme Court of India. And he is associated with me. And he is a convener of this Nani Palkhivala National Club. So friends, welcome to all 5 AORs whose tricks you will get today how to crack this AOR examination. जैसे बाकी एग्जामिनेशन होते हैं ना, वैसा ही AOR का एग्जामिनेशन है, लेकिन बहुत टफ रहता है. 60% को पासिंग रहता है. 4 साल practice in lawyer. After completing 4 years as your legal practice, then you have to join 1 year internship with any AOR in Supreme Court who have more than 10 years experience. Then you can fill the form of AOR examination. And after clearing AOR examination, then you will be advocate on record in Supreme Court. और सुप्रीम कोर्ट में एडवोकेट ऑन रिकॉर्ड का और बाकी एडवोकेट का क्या रोल है? तो एडवोकेट एंड रिकॉर्ड कैन फाइलिंग्स, कोई भी एप्लीकेशन फाइल करना है, फाइल एक सब एडवोकेट ऑन रिकॉर्ड करता है. और बाकी भारत का कोई भी लॉयर आर्ग्यू कर सकता है सुप्रीम कोर्ट में, क्योंकि हमको जो राइट टू आर्ग्यू मिला है एज पर एडवोकेट एक्ट, ये राइट टू आर्ग्यू वी कैन आर्ग्यू इन एनी कोर्ट ऑफ इंडिया इंक्लूडिंग ट्राइब्यूनल, सुप्रीम कोर्ट. इसलिए आर्ग्यू करने के लिए हमको कोई भी भारत का कोर्ट नहीं रोक सकता, लेकिन फाइलिंग के लिए रोक सकता है. इसलिए कुछ हाईकोर्ट का भी अपने अपने AOR का पैनल अलग रहता है, और कुछ सुप्रीम कोर्ट का जो है दुनिया में भी देखा है, सुप्रीम कोर्ट के पैनल अलग ही रहता है. तो यहाँ पे हमारा सुप्रीम कोर्ट में AOR का एग्जामिनेशन होता है. जैसे बॉम्बे में भी AOR सिस्टम है, लेकिन वहां पे एग्जामिनेशन नहीं होता है. एडवोकेट होने के बाद बॉम्बे हाईकोर्ट का AOR का खाली आप रजिस्ट्रेशन कर लो, यू कैन फाइल द केसेस देयर. तो ऐसा एक AOR का सिस्टम है. तो 4 years minimum practice in your legal field, then 1 year internship any more than 10 years practicing AOR in Supreme Court. That time then you can apply for this examination. And examination carries 4 different subjects. That 4 different subjects are practice and procedure of Supreme Court. It carries 100 marks and time limit for writing that paper is 3 hours. Second paper is of drafting, and drafting carries 100 marks, and out of that 3 hours writing paper, but half hour you will get for reading newspaper, reading your question paper extra. Then paper 3, professional ethics, and you will get 3 hours for writing paper, 100 marks paper. And fourth is leading cases, 64 leading cases. If you think all papers are scoring, and if you think all papers are challenging also, that it depends upon how you practice. So I will add on some things after each speaker's tricks because they have already passed. I have not passed this examination because I am an arguing counsel. In my law firm, there are 12 juniors. Out of that 12 juniors, 5 are AOR. And my books are there for AOR examination because in this age, when I joined Supreme Court after Bombay High Court practice, I was at that time 84, 54 years old. Now I'm running in 60s. So we don't want to become AOR and filing the cases in Supreme Court. So we don't become AOR. My juniors are AOR. And anybody from India can become AOR by cracking this examination, and they can shape their future, brighter future in apex courts of India. तो चलो दोस्तों, आज हम आपको बताते हैं कि जो हमारे आज 4 पार्टिसिपेंट हैं उनके मार्क्स भी बहुत अच्छे हैं और हमने पोस्ट में शेयर किए हुए हैं मार्क, ताकि आपको पता चले। एवरेज पासिंग इसका 50 मार्क्स के ऊपर रहता है, लेकिन एवरेज चारों सब्जेक्ट का मिलके 60% आना चाहिए। तो किसी में अगर 65 है और किसी में 55 है तो एवरेज हो जाएगा, ऐसा है। और कोई भी एक सब्जेक्ट में भी आप किसी एग्जामिनेशन को पास हो जाता है ना, दैट टाइम यू कैन गिव एग्जामिनेशन दैट टू सेकंड अटेम्प्ट, लेकिन पूरे सब्जेक्ट देने पड़ते हैं। लेकिन कोई बंदा अगर चारों सब्जेक्ट में पहले एग्जामिनेशन में ही फेल हो जाता है, 40 के नीचे मार्क्स आते हैं, 50 के नीचे, 40 के नीचे ऐसे मार्क्स आते हैं, तो उसको वो एग्जाम वापस देना अलाउड नहीं है, देने नहीं देता है। फिर चीफ जस्टिस ऑफ इंडिया का परमिशन लो वगैरह, ऐसे कुछ प्रोसेस है उसके लिए। बट यू हैव टू क्लियर दैट एग्जामिनेशन विद इन 4 अटेम्प्ट्स ओनली 4 अटेम्प्ट्स मिलता है। इसलिए वाइजली देना। कुछ कुछ लोग रहते हैं फर्स्ट अटेम्प्ट में क्लियर कर लेते हैं, और कुछ कुछ लोग रहते हैं 4 अटेम्प्ट में भी क्लियर नहीं कर पाते बिकॉज ऑफ देयर राइटिंग स्पीड्स। यस, नाउ सुमित कंसल, let me search so I can mute Sumit mic. Sumit, can you hear my voice? Yes. Just a minute. Ask to mute. Yes. Now you can mute yourself. Yes.
Yes. Now it's on.
Are
you able to hear my voice, Somani ji?
Yes. Just hold on a minute. मैं स्पॉटलाइट पे लेता हूं आपको, तो आप सबको दिखाई देंगे। और सुमित जी, आपको बहुत अच्छे मार्क्स मिले, मैं आपको अभिनंदन करता हूं।
आपको थैंक यू सो मच।
यस, पेपर 1 में प्रैक्टिस एंड प्रोसीजर में 74 मार्क्स हैं, ड्राफ्टिंग में 67 मार्क्स हैं, पेपर 3 फंडा प्रोफेशनल एथिक्स में 63 मार्क्स हैं, एंड लीडिंग केसेस में 70 मार्क्स हैं। बहुत अच्छा परसेंटेज आपने निकाला है। तो लेट मी आस्क यू क्वेश्चंस, और आप क्वेश्चन को जवाब देते देते हम आपसे निकाल लेंगे जो निकालना है ऑडियंस के लिए।
I'll be most happy to help you and answer any questions.
और सबसे बड़ी बात कि हमारा जो एपेक्स कोर्ट है, सुप्रीम कोर्ट में आपका ऑथोराइज एंट्री हो गया बाय क्रैकिंग दिस एग्जामिनेशन। मैं पूरे एससीबीए की ओर से और स्कोरा की ओर से आपका वेलकम करता हूं सुप्रीम कोर्ट के लिए। और
थैंक यू सो मच।
आपको हम अलग अलग पोजीशन पे फ्यूचर में सीनियर डेजिग्नेटेड लॉयर, फ्यूचर में जज बोल के सुप्रीम कोर्ट के एज एलिवेटेड जज, ये सब देखना चाहते हैं। उसके लिए जो भी सपोर्ट लगेगा ये आप जरूर करेंगे आपको, डोंट वरी अबाउट दैट। अभी मुझे ये यस मुझे ये बताइए कि थोड़ा सा आपका बैकग्राउंड क्या है?
All right, I'll just convey. So good morning everyone, and I am much thankful to Nani Palkhivala Club and Somani ji and Chaudhary ji for inviting me here, for giving my insights and guidance on the AOR examination. So by God's grace, I could clear the exam in my maiden attempt with only 20-25 days of study. So friends, I am Sumit Kansal. I am a qualified chartered accountant of 2011 for almost a dozen years now. and I am also a practicing lawyer since 2017 for over 6 years. And as you all know, have recently qualified as an AOR. So I come from Ambala, sir. I come from Ambala, Kent, is a town in Haryana. And I did my BCom honors from Shri Ram College of Commerce in 2007-2010 batch. CA again was my first attempt. I cleared both the CA inter and CA final in my maiden attempt. And then I joined law. So I am a gold medalist in law. I got 6 gold medals. And thereafter, I started almost after working for almost a year with a lawyer. I then started my own chambers. I have my practice with a firm named Kansal Law Chambers. It's a niche practice in corporate commercial tax laws. I am based out of Connaught Place in New Delhi. So I have a team of 5-6 people with me, and we work across forums, especially having practice before arbitration, NCLTs, tax tribunals, and commercial courts. So that is it about it. And now to start with, so friends, see, an exam is not an easy, I'll start with, is not an easy or a difficult exam. It depends upon your preparation, your mindset, and understand the strategy of what is required from you regarding a certain exam. AOR exam is no different. So I'll start with giving 4 or 5 pointers which I think are pertinent and which would be different from the general league of the advice and the guidance given. And then I'll just run you through, because I've been given a 10-15 minute slot, and another 5 or 7 minutes I'll run you through the question paper which we attempted in the last exam. So first point is that please understand that this exam, apart from the other 3 exams, is of 3.5 hours. That means that you get 30 minutes in the starting to read the question paper, and depending upon the examination hall or the examiners, they sometimes give you the answer sheets also in the very starting. So having said that, even though you get an additional half an hour in this exam, time is of essence, because this is a very difficult paper that you have to write in all those designated 3 hours, because writing can only be done after that half an hour. And so it's a little challenging. Now, what is the strategy here? What I did was, first, once you get those answer sheets, please mark them, please number them. Once you number your answer sheets, you understand this is the total pages, and there are generally 5 questions to attempt. This is what the past exams have shown, which are of 20 marks each. So even though there is no bar to get additional sheets in the examination hall, however, there is a bar to our writing, which can be maximum 25, 30 or 35 pages to be written in those 3 slotted hours, depending upon your speed. That is why I say that you have to balance and you have to give 4 or 5 pages to each answer, so that you understand that this is the pages I have written, and this is the content I have written, and this is the time period in which I have written. So the total time to us is 180 minutes, in which you have 5 questions to attempt. So let us consider that you have around, if I say around 35 minutes for each answer to be written in this particular paper. Another challenge is that generally there is no choice given in this paper. So you must understand all the formats. You cannot just shrug your shoulders stating that I can skip an election petition or a criminal contempt or a transfer petition which is civil in nature. So you must number your answer sheets, and then in those 30 minutes is where the importance is. One more peculiar thing about this exam is, this paper is that it is a battle of nerves. Unlike paper 1, which is practice and procedures, that is essentially the jurisdictions before the Honorable Supreme Court, and paper 3, which is professional ethics, you have to mug up to an extent. If I could candidly say that you have to exactly mug up Article 129, Article 130, Article 141, all those Article 136, the exact language, the bare language from the bare Act of Supreme Court rules, and the Constitution of India, of course. And paper 3 also, ethics, you must know what is the rights, duties of a lawyer. However, in paper 2, you cannot mug up anything. I would be afraid to say that for a regular practitioner, this paper would be very easy. Unlike that, he practices before the Honorable Supreme Court. He might be practicing before the district court, because the formats are similar in nature. or he may be practicing before the honorable tribunals. But once he knows drafting, then it becomes very easy. You just need to know the formats. But if you are not practicing, it might be a little difficult. So what I suggest is that you practice at least 3 to 4 times in this. I think 1 month is there now before the exam comes in June. And that practice makes a difference. It is a battle of nerves. You don't mug up anything, but in those 3.5 hours is the difference. So please have proper sleep. In our time, these exams are consecutive. I think there is a holiday also in between. I'm not very sure, just check. And please take proper sleep, and please be very alert once you attempt this question paper, because there is no material to study in this paper. But how alert you are, if you see the questions might be very complex in nature, and that is where you have to apply your mind. You apply your mind to read the questions, you amalgamate, you absorb. That is the processing, step 2. And the third is act. You execute by writing it on the question paper, on the answer sheet. So I would suggest that you don't start from answer 1, depending upon your ability. You start from a mediocre kind of a question, which is mediocre in nature. Once you attempt 1 or 2 questions, you will be in the flow of things. The momentum will be maintained, and then you can take up that complex question. So meaning thereby that the 5 questions may not be evenly balanced. 2 could be complex questions, 1 could be quite easy, and 2 could be mediocre, generally speaking. So accordingly, you have to see. Another thing which I felt is that if you have that 35 minutes, you might take 5 minutes extra to write properly rather than writing more. Meaning thereby that instead of 5.5 pages, we write 4 pages or 4.5 pages, but the correct questions of law, grounds should be written. See, this is not an exam. It's not clerical in nature, or it is not rote learning that you borrow something from the question itself. The facts will be given. You know the law because you are a lawyer, but then that is where the questions of law come in place, because you know the law, and sometimes it is appendix to the questions also. In our time it was, they give the acts provisions also. But then the grounds, there is your creativity coming in. There is where you synthesize the facts with the questions of law to make up those grounds. Those cannot be merely grounds that because the Honorable High Court or the lower court erred in law, did not appreciate. You have to say why. Why was it done? You have to give a proper reason. You may not write 10 grounds, write 3 to 4, but good grounds, solid grounds with proper backup. Synthesizing the facts with the law, with your corresponding with the questions of law. So that is important. Next point is subrogation. You have to step into the shoes of the judge or the examiner. There are 40 to 50 sheets or cases listed before the honorable judge, akin to a judge. So examiner will have to, your sheet should stand out. See, this is not an exam in which after qualifying this exam, you have an interview. All right, there is no personality test. So the body language has to be shown from that answer sheet itself. How? You may carry a paper, pencil, or a scale, and you do the proper formatting. It should be legible handwriting. You must see that if the answer sheet is full, your writing should not come in between. So you must see from you cannot see here from a client's point of view or from your own point of view. You have to see from the judge's point of view what he wants you from the answer. Don't suppress any facts, but try to combat them with your arguments, if it is on the weaker side or coming from the opposite side. So you are attempting an exam for the highest constitutional court in the country. You must understand that the quality is high, and how it is achieved is by practicing, by knowing and understanding those facts. So another thing is that sometimes there is a format which is given. For example, you have the Supreme Court rules 2013, and then there is this form number 28 for an SLP, which is both for a SLP, civil appellate jurisdiction is given. So you have to write that proper format. That is important. So sometimes people make a mistake that they don't write the position of the parties properly. So that is very important. Then you also have to write the Supreme Court particular rule. For example, this is Order 21, Rule 31A, the civil appellate jurisdiction of the SLP civil, form number 28. So there is a proper format for this particular thing. Unlike a review petition in which you can have your own kind of a thing, there is no set format as such. So there are 8 parts to it. And the interim application, the interim relief is a part of this SLP civil itself. There is no separate kind of an application to this effect. Now coming to the next, I would say that you might start reading paper 4, which is your case laws, which again is a open book exam and there is no mugging up. And once you start reading a judgment, stop in between of the judgment. You understand this is the facts of the case. This is the petitioner's argument. This is the respondent's argument. And then you close that book. You make your own arguments that this should be the questions of law. These are the issues. And then you see from those judgments, because those are landmark judgments, those are decided cases, so that you will be able to understand how the drafting is done, because the judgment is already in place and it's a leading paper also. And in this way, two of your papers can get simultaneously studied. Now, the prayer is also very important, which you must understand what is the relief you are asking. So what is the requirement? Along with this, I would say when you start your para 1 of any petition or any application, you must start it with small sentences. Don't make it very complex. Sometimes the trick is that sometimes we put two arguments in one sentence or one fact and law. So that should be prohibited. You might add small sentences understandable to the examiner. See, they're not testing your English. They are not testing that very flowery language. You have to synthesize something which is very complex in a very simple, decent manner. The way we tell to a client on the factual side, we tell here to the examiner on the legal side with our legal acumen. But it has to be in simple tone. First para should set the tone, the base of what is being asked. So this is the facts of the case. This is the impugned judgment and why we are here. And we are here through this remedy. So obviously you are all lawyers. You know that SLP remedy is different, rate is different, a civil appeal is different. So this is how it is. And please segregate the chaff from the grain. The facts versus law are different. Why I say so? Generally, sometimes in questions of law, questions of fact are written. This is a court in which questions of law are asked in the constitutional courts, in the High Court and the Supreme Court. Don't concentrate on questions of fact. Fact will come in what is the facts of the case. There it will be asked. So that is there. And I would say that you finish all the answers, attempt all of them. There is no negative marking here. It's not an objective exam in which you have a 0.25 or a 0.5 marking or an examiner is judging you. If there is a certain weak question which is very difficult for you to answer, which I also did, there was a difficult question, perhaps of an election petition or a genealogy question, which was question number 3. I attempted it in the end. So this is how it can be done. And so I'll just take you to the question paper. If sir may allow, I'll just take 4 or 5 minutes, Somani ji, if that is fine. Yes, and I'll just run them through. So once you make that sentence, it should convey just one idea only. And sometimes there is certain kind of a petition. I'll just show you with these, because these were all 5 different questions which came in paper. No 2 were asked similarly.
ये मीटिंग ऊपर होने वाली है क्या? अच्छा.
All right. So this question number 1 in the last paper was a election petition. So sometimes one may not be knowing the format because it is little tough and out of the league. But appendix was the representation of the people Act 1951 and the election symbol order was also given. So it becomes easy for us that the law is already given, facts we understand. Now we have to apply our mind.
Just hold a minute. Just hold on a minute. Yes. Yes, Subiji, can you mute? Can you mute? Check. Just hold a minute. Yes, Subiji.
All right. So what happens is that once you get those 30 minutes, I would just suggest, because you just have now 1 month to go for this paper number 2 drafting, that one is that this is very different from the pleadings or the drafting which we do in the court of law. Here they are only interested in understanding what is the heading. You know that it's an original jurisdiction or an appellate or it's a writ petition. what is the Supreme Court rule, what is the particular article. Now, sometimes there is a case study, it's a trick that they ask, it is pertaining to 2014. And 15, they go, the impugned order of the Honorable High Court, the particular jurisdictional High Court, is of May 2015. Now, you have to appeal to the Supreme Court. Now, for that, writing that, you write a civil appeal dash of 2015. Don't write of 2024, because you are filing it in 2015, right? Now, so that is the format, basic format, and then your content is very important. They are not interested in knowing what is the index or what is an affidavit. It obviously depends upon the instructions of the question paper. In our times, it was clearly given, but it's not the general thing as is done, which are generally the clerks do. But what is the content, that is more important. That is what they are interested in actually. So the question number 1 was draft an appropriate petition on behalf of the election petitioner. So that means that it is a question of an election petition. This was question number 1 which came, and the law, the act and the order was annexed to it. So for our understanding. Now see, in those 30 minutes which you get, you should try it at your home also. I would suggest keep 2.5 hours for the exam, attempting each of the answer in half hour, 30 minutes. And before that, take those 30 minutes, before that 2.5 hours, those 30 minutes to read the question paper at home and try to see if you are able to amalgamate all the 5 questions or 3 or 2. Now, in your examination hall, if you're comfortable to understand all the 5 questions in those 30 minutes, in the starting 30 minutes, it's good. If not, again, good. Don't try to read the entire question paper and not understand even a single question, meaning thereby that you may understand 2 questions, giving 15 minutes each in those 30-minute slot, so that you are well aware of what these 2 questions are and read the other ones after those 30 minutes. So that 30 minutes should not get useless that you read the entire question paper and don't you understand anything, because it's a difficult. This reading is hardcore. It is difficult. Now, question number 2 was a review petition, which I just want to bring forth. It's very critical. Apart from your technical skill of facts, legal, here is where, especially in the review petition, your soft skills come into play. You cannot write that we are prejudiced with the court's order, did not appreciate the facts, because you are into review or you are into a curative. Curative or a review is before the same bench. You have to be very polite. You may say that the honorable court, it might have escaped the attention of the honorable bench. Maybe there was an inadvertent error that crept in, or this is the situation that may consider this appropriate remedy or alternative strategy, because you are at the highest constitutional court and you are into review. So now here the kind of tone and the language becomes very important. So this was actually a question on review which came, and I would suggest that certain things are peculiar also. You must write that the certificate from the AOR for this review is attached, which is a mandatory condition as per the Supreme Court rules also. Now, third question was a genealogy question, which was quite a tough question. It was a family tree in which there was one person. And if my friends are having this question paper, could be downloaded from the Supreme Court website also. If we clearly see up till para 6 of this question paper were the facts. Now, para 7 says, Asha only examined herself and Babita as PWs, which means the legality is coming into play, and Asha died and the Babita was substituted as the plaintiff in the title suit. So the legality is coming into play. And in para 11, it says the Honorable High Court held as under. So this order, the operative order, was the impugned order which came into play, which is now assigned before the Honorable Supreme Court. So this can be known when we read the question paper. And then there was question 4, which was a transfer petition. Now, here your creativity also comes into play. There was this journalist who was getting aggrieved with certain kind of political vendetta there, and he wanted that the petition should be transferred because there was certain collusion going on. Now, you have to write, because it is not written, you have to write what are the compelling grounds why the transfer petition should stand in the first place. Maybe he's the sole breadwinner in the family, he is recently married, or he's a small child who is an infant, and it is easier for him to commute here, and he has a long standing and he has other works also to do, maybe on the field. So these kind of things, your creativity will come into play. And similarly, question 5 was a PIL in which the name of the association was not given. So it was a PIL which has to be filed, but it can be filed through some welfare association. So you write the name of that association, you write certain ministry, which is the corresponding ministry of the government of India, or it was an Indian Medical Association, which was also respondent here. And then when you file it by a secretary or a chairman of that association, you also file an annexure to that effect, which is a resolution or an authority letter. So this is where the question paper will be silent, but your creativity, your understanding, and your practice will come very handy here. So these are certain tips, and I think would come handy, which would be a little unique, and which I also applied in my exam. And it was a tough exam, as to be very honest, which I did felt, and I could really see when Somani ji, when people came in the third paper, it was almost 50%, because the paper 2 was really technical, but that is how it is, and it should be like that, because the quality AORs should be coming in, but
yes.
certain practice is required in this paper, and then one, I think, should be, I'm confident, should be able to sail it through.
Very nicely you explain everything with your meritorious thought.
Thank you, sir.
मैं कुछ ऐड करना चाहूंगा दर्शक के लिए कि अभी कम से कम मैं 2018 से सुप्रीम कोर्ट आया हुआ हूं. अभी तक मैंने 400-500 से ज्यादा केसेस फाइल किए, आर्ग्यू किए, मोर देन 1500 मोर देन अपीयरेंसेस आई हैव गिवन. तो प्रैक्टिकली मुझे ये बात पता चली है कि क्वेश्चन ऑफ लॉज एंड ग्राउंड्स आर डिफरेंट. सम क्वेश्चन ऑफ लॉज कैन बी अ ग्राउंड, बट नॉट ऑल क्वेश्चन ऑफ. लोग क्या करते हैं, क्वेश्चन ऑफ लॉज को खाली वेदर निकाल के और उसको बिकॉज टैग लगा के और उसका इंट्रोडक्टरी इसको क्वेश्चन का जो फॉर्मेट है वो चेंज करके उसको ग्राउंड बना लेता है. तो ऐसा अगर करते हैं तो वो समझ जाते हैं एग्जामिनर की नहीं आ रहा है, आपको ग्राउंड क्या होता है ये पता नहीं है. क्वेश्चन ऑफ लॉज अलग होते हैं, ग्राउंड्स अलग होते हैं. एसएलपी के ऊपर क्वेश्चन आना ही आना है, रिट पिटिशन के ऊपर क्वेश्चन आना ही आना है, काउंटर एक्ट के ऊपर क्वेश्चन आना ही आना है, ये याद रखना है. और इसमें सबसे इंपॉर्टेंट है कि आपका राइटिंग स्पीड. अगर रोज 1.5-2 घंटा आप लिखने की प्रैक्टिस अगर आखिरी 30 दिनों में करते हैं, ये जो हमारी छूट गई है, हमको टाइपिंग का प्रैक्टिस है. मैं तो रिकमेंड करूंगा हमारे रजिस्ट्री को जो ये एग्जाम कंडक्ट करते हैं कि भाई ये एग्जामिनेशन के लिए इंस्टेड ऑफ पेपर आप खाली कंप्यूटर अलाउड कर दो या लैपटॉप अलाउड कर दो. कम से कम वो कॉस्ट टाइटल लिखने में जो समय जाता है ना, वो हमारा एग्जामिनर जो एग्जामिनर ही रहेगा वो उसको कट पेस्ट करके अगले क्वेश्चन को ले सकता है और थोड़ा स्पीड बढ़ा सकता है. लेकिन यहाँ पे अभी तो पेपर पे ही है, तो देयर इज नो अल्टरनेटिव. तो थोड़ा लिखने का प्रैक्टिस करो अच्छा. और हमारा जो ड्राफ्टिंग का पेपर है, जो एकता वर्मा ने मुझे असिस्ट किया है ये कंपाइल करने के लिए, ये ड्राफ्टिंग के पेपर में हमारा जो बुक्स है जो अमेजोन के ऊपर या फ्लिपकार्ट के ऊपर अवेलेबल है, ये साल ही है. आपके समय में ये आपको मिला नहीं क्योंकि पब्लिश नहीं हुआ था, अभी हमने पब्लिश किया है. तो इसमें ऑल टाइप ऑफ ड्राफ्ट हमने कवर किए हैं. जितने ड्राफ्ट सुप्रीम कोर्ट में यूज होते हैं सभी ड्राफ्ट हमने कवर किए हुए हैं. तो वो ड्राफ्ट के अनुसार आप प्रॉपरली अपने ड्राफ्टिंग कीजिए. और फर्स्ट एटम, सेकंड एटम, ऐसा कोई प्रॉब्लम नहीं रहता है. काफी लोग हैं, जैसा मेरा जूनियर है निशांत वर्मा फर्स्ट एटम में क्लियर हो गया था AOR एग्जामिनेशन. तो ऐसा क्लियर फर्स्ट एटम में भी क्लियर हो सकते हैं, या 2-3 एटम भी लगते हैं तो कोई प्रॉब्लम नहीं. AOR बनना इंपॉर्टेंट है. हाउ मच परसेंटेज यू आर टेकिंग दिस एग्जामिनेशन ये मायने नहीं रखता है, लेकिन आप एक बार क्लियर हो जाते हैं एग्जामिनेशन, एक कॉन्फिडेंस लेवल बढ़ता है. और जो यंग लॉयर रहता है, यंग लॉयर अगर AOR बन जाते हैं ना जल्दी, तो उनका स्टैंड सुप्रीम कोर्ट में होना थोड़ा फर्म अच्छा होता है. तो वो हिसाब से, सो दिस इज दी वे ऑफ राइटिंग द पेपर ऑफ इन ड्राफ्टिंग पेपर. तो बहुत अच्छा एक्सप्लेन किया सुमित जी. तो और सुमित जी, मैं इंसॉल्वेंसी प्रोफेशनल हूँ. तो ये इंसॉल्वेंसी का एग्जामिनेशन मैंने 8 बार फेल हुआ है उसमें. ये लोग 4 बार में क्लियर हो जाते हैं. हम लॉयर लोग हैं ना, तो लॉयर लोगों को मैं तो 8 बार दिया हूँ. इसलिए मैं लोगों को बताता हूँ कि कंसीडर, कि भी आप ऐसा कंसीडर कर सकते हैं, आप बुद्धू आदमी है, सोमानी 8 बार एग्जाम देना पड़ा, बराबर है. और ऐसा भी कंसीडर कर सकते हैं कि ये सोमानी ज्यादा होशियार इंसॉल्वेंसी में कि 8 बार इसकी रिवीजन हुई है सब लॉ को. तो ऐसा है. तो अभी
I remember our times we were struggling to get a good book on drafting, so this I think book will come very handy, because सब drafts एक जगह आ जाए ना compilation, because है तो वो set 15-20 हैं, लेकिन उनमें से कोई भी आ जाता है, and sometimes there is no choice also, so then it becomes easy. राइटिंग तो वहाँ क्वेश्चन पेपर में देख के करना है कैसे होगा, बट फॉर्मेट अंडरस्टैंडिंग प्रैक्टिस
मेनली क्या होता है 131 का जो ड्राफ्ट रहता है ना, वही
ओरिजिनल
आदत नहीं रहती है हमको प्रैक्टिस में, क्योंकि 131 हमारे पास आता ही नहीं है। क्योंकि एक राज्य से दूसरे राज्य में जो झगड़ा चल रहा है वो सुप्रीम कोर्ट में आता है ओरिजिनल जुडिक्शन में अंडर आर्टिकल 131। ओके, या 2 स्टेट एंड सेंट्रल है, इसका भी आएगा, या 1 स्टेट सेंट्रल है। तो ये, तो इसके जो है एडवोकेट जनरल रहते हैं, उनके सॉलिसिटर जनरल रहते हैं हमारे, या एडवोकेट जनरल, इनकी टीम ही ड्राफ्ट करती है। ये कॉमन लॉयर के पास हमारे पास 131 का ड्राफ्ट कभी प्रैक्टिस में आता ही नहीं है, इसलिए ऐसे कभी ड्राफ्टिंग पूछ लेते हैं ना तो गड़बड़ होता है। इसलिए ऑल शुड हैव द ड्राफ्टिंग फॉर्मेट, तो ये हमने प्रिकॉशन रखा है। और सुमित जी ऐसा मत समझना कि हमने वर्चुअल लेके हमारा रिस्पॉन्सिबिलिटी खत्म कर दिया, नहीं। हम और आज जो 5 AOR का हम सम्मान कर रहे हैं, सब हम साथ में खाना खाएंगे, हम सुप्रीम कोर्ट पे कैंटीन में खाना भी खाएंगे, उसका फोटो निकाल के हम शेयर भी करेंगे हमारे सब पार्टिसिपेंट को, और एक तरह से सम्मान हम पर्सनली भी आपका फिजिकल मिलके करेंगे। Thank you.
Thank you so very much
for joining us.
We'll be looking forward to meeting. Thank you sir.
Thank you. चलो दोस्तों, अभी हम इनवाइट कर रहे हैं भास्कर आदित्य। भास्कर आदित्य, कैन यू मनोज? क्या है? भास्कर आदित्य goes to other meeting, so skip and call paper 3. Okay, Bhaskar Aditya is not here, and Monica Benjamin. Monica ma'am? Yes, I will unmute you. Now you can unmute.
Hello.
Yes.
Yes, sir. Yes, sir. I can finally, yeah, I unmute myself.
Yes. Thank you very much.
Hello,
to
sir.
join here.
Thank you so much for asking me to be a part of this.
Yes.
My colleague, my contemporary, Mr. Sumit, has explained so well. And so there's very little for me to add to what he's already explained. But I've been asked to speak a little bit on paper 3. So I will just share a few things.
Just hold on for a few minutes.
Yes.
Let me introduce you in proper way first. Monica Benjamin, she got 79 marks in paper first, practice and procedure of Supreme Court. She got 62 marks in paper second, drafting. She got 74 marks in paper third, professional ethics, and she got 64 marks in paper 4, leading cases. So now you can explain how you study, what is your background, and even though some points are repeated, suppose सुमित जी ने जो कवर किए उसका कुछ रिपीटेशन भी होता है ना, नो इशू, बराबर है। तो कोई रिपीटेशन भी हो गया तो चलेगा, लेकिन आप करो। और तीसरा जो पेपर है प्रोफेशनल इथिक्स का, उसके बारे में आप एक्सप्लोर करके थोड़ा बता दो।
Sure,
में हिंदी भी बात किया तो चलेगा, क्योंकि बिकॉज हिंदी बेल्ट लॉयर, डिस्ट्रिक्ट कोर्ट लॉयर ना, समटाइम्स दे आर वेरी कंफर्टेबल टू लिसन इन हिंदी इंग्लिश कंबाइंड लैंग्वेज ऑल्सो.
Right, understand.
And which language you are comfortable, you can speak, no issue. Thank you.
I will do my best, sir. Okay.
Yes.
So just for starters, I'm not familiar if whether the persons who are seeking to attempt the exam have been able to obtain the study material. So the physical study material is actually available from the Supreme Court premises. And if you go to any of the photocopy shops within the Supreme Court premises, they will always guide you where to get the material from, where you can purchase the photocopy of material to study for the 4 papers. So that is one place to start. Other than that, the Supreme Court website, the new website has a special tab of advocates, under which there's another tab of AOR examination. There you will find all the previous lectures, videos, as well as study material and previous year question papers. तो आपको फिजिकल स्टडी मटेरियल सुप्रीम कोर्ट की प्रेमाइसिस से मिल जाएंगी. अगर आप किसी भी फोटोकॉपियर के पास जाइएगा, वो आपको बता देंगे एंड दे विल प्रोवाइड यू अ कॉपी ऑफ दैट. यू विल हैव टू पे व्हाटएवर लिटिल दे रिक्वायर फॉर सप्लाइंग दैट स्टडी मटेरियल फॉर द ऑल द 4 पेपर्स. एंड मैंने जो भी थोड़ा बहुत वो कोड करते वो बस आपको पे करना पड़ेगा, पर वो फिजिकल स्टडी मटेरियल आपको वहां से मिल जाएगी. और सॉफ्ट कॉपी स्टडी मटेरियल की प्रीवियस ईयर क्वेश्चन पेपर, लेक्चर, वीडियो जितने भी हैं, वो सारे आपको सुप्रीम कोर्ट की वेबसाइट से मिल जाएंगी. जो नई वेबसाइट है उस पे एक एडवोकेट्स का टैब है, जिसके अंडर एक और AOR एग्जामिनेशन का टैब है, जहां पे आपको ये सारी इंफॉर्मेशन, डिटेल्स, वीडियोस, प्रीवियस ईयर क्वेश्चन पेपर, स्टडी मटेरियल, नोट्स, बहुत सारी चीजें हैं, रिसोर्सेज हैं जो आपको मिल सकती हैं वहां से. तो मैं हाईली रिकमेंड करती हूँ कि आप ये 2 चीजें एक्सप्लोर करें. एटलीस्ट वेबसाइट को एक्सप्लोर करें और वहां से जितना भी मटेरियल है आप डाउनलोड कर लीजिए, ताकि एटलीस्ट आप वहां से स्टार्ट कर सकें. Other than that, I feel for the 4 papers, I think the drafting paper, I have heard it is lately been quite difficult to clear. But oftentimes actually because usme it's to deal with drafting, so students kya hota hai, like those advocates who want to give that a paper, hum kind of become a bit relaxed because there's not much to study. It's more to do with drafting. But I would seriously say that in order to approach the drafting paper, I think you should look at the leading cases, because a lot of the examples in the drafting paper are picked from leading cases. So make sure that you go through the leading cases, at least study some of the major important leading cases, so that you will be able to identify similar factual situations in the drafting questions, because they often pick up or formulate the drafting questions from the leading cases. So that is one way to give a little bit of guidance. Other than that, I highly मैं recommend करती हूँ कि previous 5 years के question papers at least आप लोगों को study करने चाहिए. तो उससे आपको पैटर्न समझ आ जाएगा और क्या इंपॉर्टेंट क्वेश्चंस हैं जो रिपीट होते हैं हर साल, वो आप आइडेंटिफाई कर सकते हो और उस पर आप फोकस कर सकते हो. तो एटलीस्ट यू नो दैट यू कैन एटलीस्ट पास एंड क्लियर द पेपर विथ ईज. So you must study at least previous 5 year question papers to ensure to identify which are the important questions you need to cover. Other than that, please, make sure you at least go through the BEAR Acts, the Supreme Court rules, as well as the Advocates Act for paper 3. Very important for you to go through those BEAR Acts. And there is also the Supreme Court Practice and Procedure Handbook, which is also available on the Supreme Court website. Please download that and please study that very well. That would be very, very helpful. If you look at the previous year questions, you will see you will be able to get your answers from the handbook. So make sure you have the handbook, download the handbook and study it thoroughly, bookmark it, and make your notes accordingly, and try and solve the previous 5 year question papers, so that you know the answers of the most common questions at least, and at least you will be able to answer those when you sit for the paper. Other than that, I would highly recommend Supreme Court of India, the board of examination, they also conduct their own lectures. So I would also recommend that आप सुप्रीम कोर्ट के जो बोर्ड ऑफ एग्जामिनर हैं वो एक लेक्चर सीरीज कंडक्ट करते हैं, which I was always told to attend those lectures, because they give you the most important questions for that particular year. So it's very important for you to attend those lectures. And yes, other than that, I would highly say that Mr. Sumit, all those points which he had shared would be very helpful if you are able to follow those. As for paper 3, I can say is that for paper 3, please be very thorough with the Advocates Act. It's a very, very small BEAR Act, so there should not be much difficulty. Other than that, there are a lot of cases with respect to the different questions which are asked, like what is advocacy, and in what, like the cases on strike and contempt cases. Those are very important questions and they come every year. So please make sure you study those cases for those particular topics, so that you are able to attempt those questions. For this, I again tell you to please look at the previous 5-year questions and identify the major recurring questions which are coming, and accordingly prepare those questions. And one thing you also need to keep in mind is कि even though आप 5 साल के questions देखते हैं, तभी it happens that sometimes the question paper pattern changes. And I have seen that happen. It happens sometimes in drafting, it happens sometimes in advocacy and professional ethics. So please be very mindful of that, and don't at least prepare in a way so that you are not completely scared from looking at the new question paper pattern. Essentially, the questions would be the same. It's just that probably the scoring would be different, and maybe there will be a lot more compulsory questions, or a lot less objective type, or a lot less subjective. So in case of advocacy and professional ethics, I personally feel it is a very good scoring paper. And at least for the past 2-3 years, they've been giving, at least past 2 years, they have 20 marks of objective questions where you just choose the right answer. So, or you give very short answers. So those 20 marks, which compulsory 20 marks, are very easy to score. But it's important that you are able to at least prepare those questions in advance. So please, I would highly again recommend that you go through at least last 5 years questions, and especially the last 2-year question papers. So first 20 marks are compulsory, so please attempt. And also it's very, very important that you finish your paper. Even if you are not able to write much, it's very important that you try and attempt all questions. सारे questions attempt करिए, कोई question मत छोड़िएगा, because छोड़ने से आप वो even a few points you lose that if you don't attempt that question. So it's important that you attempt all questions. You maybe have to compromise on how much you're writing for a particular answer, but please make sure you attempt all questions. And yes, I think that is roughly what I can advise all the candidates who are seeking to attempt this examination this time. And I wish everyone the very best.
Very nice, very nice. Just I want to add one thing in this. In professional ethics examinations, if you are well aware about the case laws on professional ethics, जितने भी केस लॉज के ऊपर आपका कमांड है, और वो केस लॉज अगर आप एडवोकेट प्रोफेशनल एथिक्स के पेपर में काफी जगह पे अगर इस शॉर्ट पैरा में भी अगर वो केस लॉज डालते हैं, तो इट विल बूस्ट टू गिव द गुड मार्क्स टू द एग्जामिनर.
यस, आई एग्री सर.
यस. और मेरा इसका एक बुक भी पब्लिश है प्रोफेशनल एथिक्स का अमेज़न के ऊपर, लेकिन उसमें मैंने खाली केस लॉज दिए हैं. और जनरली लोगों को ये पेपर का स्टडी करना बॉदरेशन नहीं लगता है, क्योंकि ये एडवोकेट एक्ट छोटा है, वो हम आराम से कर लेते हैं. दूसरा है बीसीआई रूल्स है, बार काउंसिल ऑफ इंडिया के जो रूल्स है ना, आवर ड्यूटीज टुवर्ड द क्लाइंट, ड्यूटीज टुवर्ड द सोसाइटी, ड्यूटी टुवर्ड द कोर्ट वगैरह, इसके ये प्रिपरेशन करने के बाद 7 एथिक्स ऑफ द लॉयर वगैरह, ये सब करने के बाद यस, लेकिन ये सफिशिएंट नहीं है. वो यू आर गिविंग दी AOR एग्जामिनेशन ऑफ सुप्रीम कोर्ट, भारत के एपेक्स कोर्ट में काम करने वाला है. तो हमारा एग्जामिनर बोर्ड जो रहता है ना, उनका ये मानना रहता है कि इसको अगर मैं AOR करूंगा तो ये वैल्यू एडिशन क्या करेगा सुप्रीम कोर्ट में. तो वैल्यू एडिशन करने जैसी थिंकिंग है, प्रोसेस है आपकी, कोई केस लॉज वगैरह बताना, ये करना वो करना, अगर ऐसा प्रॉपरली करेंगे ना, तो जरूर ये सब्जेक्ट जो है ये प्रोफेशनल एथिक्स का, ये बिल्कुल डिफिकल्ट नहीं है. और ये प्रोफेशनल एथिक्स का सब्जेक्ट है, उसमें कुछ जो मॉनिटरी जो रिकॉर्ड रखना है, जो प्रोसीजर है मॉनिटरी रिकॉर्ड रखने का AOR के लिए, वो सब आपको अगर प्रॉपर मालूम है प्रैक्टिकली, तो बहुत अच्छा ये पेपर आपको जाएगा. और मुझे यकीन है कि ये पेपर स्कोरिंग भी सब्जेक्ट है, जैसा ड्राफ्टिंग पेपर स्कोरिंग भी है और डरावना भी है, बराबर है. वैसा प्रोफेशनल एथिक्स स्कोरिंग है, ये डरावना नहीं है. इसमें फेल होने का चांसेस बहुत कम है. लेकिन अगर आप इसके जो केस लॉज है, मैं लीडिंग केस की बात नहीं कर रहा हूँ, लीडिंग केस 64 केस की बात नहीं कर रहा हूँ, मैं प्रोफेशनल एथिक्स की केस लॉज अलग है. उतने केस लॉज का अगर प्रॉपर प्रिपरेशन कर लेते हैं, जो हमारे बुक्स में है, तो बस आपका कमांड जो है, ये कमांड बहुत अच्छा रहेगा और बहुत बढ़िया ढंग से ये करेंगे. और मुझे बहुत खुशी होती है मोनिका कि आप इतने अच्छे मार्क्स सब सब्जेक्ट में लिए हैं. तो कितने महीना स्टडी किया आपने ये AOR का?
Sir, actually, in truth, this was the last time I appeared. I was falling in the regulation, so I gave one paper which was practice and procedure, and I had to give just that one paper in order to clear. And इससे पहले I had given 2 attempts. So the third time when I had to give the single paper was my third attempt. So it was not easy because I was last 2 attempts I was giving the exam in December, which was very close to working days. So I tried whatever I could to prepare, and I mean yes, I know a lot of people, especially like Mr. Sumit, who was able to clear on their first attempt, and it requires preparation. It is not there is no shortcut to it. So, but even if I would still tell my fellow advocates that if you are unable to clear on the first attempt, don't lose heart. I would just say, just prepare again and make another, next best attempt that you can. And it is difficult to manage studying with work, but it is doable. I mean, I would recommend that you try and study at least on weekends for a couple of weeks, at least much beforehand, so that you can catch up on studying your material. And possibly when we wait for court matters, sometimes we study cases during that time also, while waiting for a matter in court. So I think it's about just managing time, but it is definitely a doable attempt, and everybody can do it. It's just a matter of putting in effort. So that's my only say on this.
Very nice, very nice. You nicely explain everything. And in next week we will meet in Supreme Court, our canteen, and we will have lunch together. All our 5 AORs today. Okay.
Yes, sir. Definitely. Okay. Thank you, sir.
Thank you, Monica. Now, Gurpreet Kaur. Just a minute. I will unmute Gurpreet. हाँ, वेलकम गुरप्रीत। आप हमारे जयप्रकाश एडवोकेट सॉलिसिटर्स, हमारा जो लॉ फर्म है, इसमें पैनल में भी है, लेकिन मिलने का मौका बहुत कम मिलता है, और आज आपको देख रहे हैं तो बहुत अच्छा लग रहा है। ऐसे गुरप्रीत, फर्स्ट ऑफ ऑल बहुत congratulations to you. You clear this examination with very fantastic marks. Let me explain your marks. Your paper 1, practice and procedure of Supreme Court, marks are 67, very fantastic. Then paper drafting 51, then professional ethics 63, and leading cases you got very nice marks, 70 marks. तो बहुत अच्छा आपने इसमें काम किया है। तो थोड़ा सा आप आपके बारे में भी बताइए लोगों को, भाई आपका बैकग्राउंड कैसा था, क्या, और उसके बाद आप ये जो लीडिंग केसेस हैं, 64 केसेस लीडिंग केसेस, इसके बारे में भी, इसका तैयारी कैसा करना है। ये काफी लोगों को एक्चुअली हेड नोट्स का बुक वो देते हैं साथ में लिखने के लिए। ये एकमात्र पेपर है AOR का, दर्शक के लिए बताता हूँ, एकमात्र पेपर AOR का कि जिसमें बुक आपको मिलता है। बाकी 3 पेपर में बुक्स नहीं मिलता है, लेकिन ये पेपर में एक हेड नोट्स का एक बुक मिलता है जो 64 केसेस का नोट्स रहे, तो उसको देख के भी आप लिख सकते हैं। लेकिन वो देख के लिखना नहीं लिखना, वो थोड़ा सा सीक्रेट जो है, ये सीक्रेट गुरप्रीत आपको बताएगी, और एंड में मैं थोड़ा एड ऑन करूंगा उसमें, जो भी मेरा एक्सपीरियंस के हिसाब से, तो वो भी मैं बताऊंगा आपको। ठीक है गुरप्रीत, नाउ माइक इज विथ यू।
Thank you so much, sir. I'm very grateful to you for giving me this opportunity to come on board and share my experience. To be very frank, what my colleague Mr. Sumit Kansal and Ms. Monica has shared, the paper is comprising of all that. This paper needs hard work, as you know, we all of us know, and we have to literally study. I mean, if I personally talk about myself, I'm into practice since 2014, and in the last 3 months when the exams are approaching, this time also I think the date for the exam is the same, 11, 12, 13, 14. Last year also the same time, in the June we had the same exams. So, I mean, last 3 months, May, March, April, and May, I didn't go to court for any of my cases. I used to send my juniors and, do my work that way. But then, regular study is what we need. And my background is that I have been into, I'm actually a triple postgraduate. I've done my MCom from Delhi University. I did my BCom honors from Delhi University initially, then MCom from DU. And then I did my MBA from Symbiosis, Pune. After doing my MBA in finance and HR from Pune, I worked in multinational companies for about 10 years. And then I had, taken up law. I completed my LLB from Campus Law Center, Delhi University in first division. And from there onwards only, we were made habitual of how to deal with the cases, because in Delhi University, the students are taught with the case material, and the case material consists of the case laws. So in the case laws, I mean, what the 64 cases which we have, the list which we have got for the AOR exam, most of these cases we had already read during our LLB. So, our teachers had taught us how to deal with these judgments when we have to do. So, the thing is that I'll just give you one example. First of all, the 64 cases list which we have got, we have to first of all categorize these cases into whether they belong to the constitutional law, or they belong to criminal law, or is it separation of power or judicial review, or is it related to judicial legislation. And there is a category of arbitration, insolvency and bankruptcy code. When you will go to Supreme Court website, senior advocate Mr. J. Savla, he had loaded one document which deals with the broad categorization of these leading cases. This is I think this is a document of about 10 pages. This was very, very helpful to me. It appears like this. When you have the categorization with you, then you can easily deal with the number of cases and what it is dealing with. So let's say when we are dealing with the constitution law, and in the basic structure doctrine, we have to read 3 cases. Keshwanand Bharti is one case, second is Minerva Mills, third is AOR Coelho. So when we are dealing with this category of cases, we have to understand whenever there is a question on basic structure of doctrine of basic structure, at that time we have to see whether it is only dealing with the issues dealt in Keshwanand Bharti, or is it only dealing with issues which were dealt in Minerva Mills or AOR Coelho. If it is a general question that explain what is doctrine of basic structure, what are the rules, and what is the ratio, in that scenario we have to mention all 3 cases. So we have to be very clear with what is the question we are attempting. So if we look at the structure of the paper, the paper leading cases paper consists of 10 questions. And I think Supreme Court advocate on record is a very this paper is a very broad choice question. 5 questions you have to attempt out of 10. So you can easily make out, once you have to plan your paper. Once you receive the paper, you have to read each question very carefully, and at least do reading of the question twice, so that you understand which question you would be comfortable in writing. Once you are, once you tick those questions that these are the 5 questions out of 10 I'm picking and I will be more comfortable in writing, then you must pick up, because see, in leading cases you get the Supreme Court head notes for a reference. So when you have the head notes with you and you have already picked up the questions which you have which you want to write down in the examination, because 60 all the questions, 10 questions will be comprising of these 64 judgments only. But it is now your comfort level. Like I am generally dealing into civil law, so I'm more comfortable dealing with civil law questions and constitution questions. When it comes to criminal law questions, I find it a little difficult to deal with those type of cases and the things. Although I did read those all 64 judgments before sitting for the exam, but it was there in my mind that when the question paper will appear in front of me, at that time I will initially try to choose 5 questions which are dealing with civil law, constitutional law, so that I'm more comfortable in writing. Once I made the choice, at that time I just put the you have to carry your flags with you. I hope everybody must be using these flags. So once you have these flags with you, at that time you can just place those flags, so that you don't have to find out the question, the Supreme Court head notes at the time of writing. So once you have chosen the 5 questions and you have identified the cases which are to be dealt in those answers, just flag those cases in the Supreme Court head notes. Now you have to, once you read the question, you have to plan your answer. Planning your answer means whether it is only dealing with the ratio of the question, or you have to give the background of the answer. So suppose we are writing doctrine of basic structure, and the question is only specifically dealing with Keshwanand Bharti case. So in that case, you have to focus only on this particular judgment, give the background of it, write down the facts in very brief. In case you have the time to write down the arguments, then you can. In case you do not have the time to write the arguments, just put the pointers that these were the submissions made by the councils, and then you have to write down the ratio, and in the end you have to write down the conclusion giving your opinion, and your opinion may not coincide with the judgment, what the judgment is, the principle which judgment is laying down. You may disagree, but that you have to be writing in a very, very manipulative way, that this is what you agree with and this is what. See, Supreme Court is the apex court of the country, but we do have a right to agree or disagree to any decision. We may disagree, but that has to be in a polite manner and not in a criticizing manner. We can put our, I mean, you must have seen that there are minority views within the judgments itself. So in that point, in those judgments where the minority views are mentioned, the judges are placing their opinion about what they think about the issue and what decision they think should be taken. However, because they are the minority and the majority rules, which is the case, so but they are still placing. So that way, in case you do not agree with the judgment or the decision, you must write in the conclusion that this is the judgment in this, the principle laid down, the ratio and the obiter dicta which is laid down in this judgment is this, so and so, but I disagree, and the reason of my disagreement with the judgment is so and so. That ways you can read, you can plan your answer. And believe me, leading cases is a very, very lengthy paper. Most of the time students, candidates are not able to complete the paper in spite of doing enormous planning, in spite of reading my judgments pre-planned, in spite of writing all the points which I had to put up in the answer. Still, I was only able to complete my paper just in time. I mean, the bell rang and the the person, he came to just take the paper from me. I could not even revise my paper. But while I was writing the answer, I had planned it in such a manner that I have dealt with each section of the question. The question may be split in various sections, so you have to make sure that you're dealing with each section in the question. And once you are writing the conclusion, once you are closing the answer, at that time you have to write the conclusion that this is what you are believing and this is what should be this is what your conclusion is here. And in case you find that there is a paucity of time and you may not be able to write it in the manner you have planned, the way that happened with me, the last answer I had written in literally lot of rush. At that time, I just made sure that I will write all the points in pointers, and I just summed it up in the conclusion. So my initial 4 answers were very, very detailed answers with everything inside, from issues and from ratio, from conclusion, everything was there. But in the last answer, I still remember I just managed to finish it. So you have to plan ahead well in advance how you want to answer, and make sure that you plan that which type of questions you would be comfortable in writing. Because if you are not comfortable writing a criminal law question, then in the exam there are chances that you may skip the points which are crucial for the answer. So plan your answer, prepare well, and I wish best of luck to everyone. Sir, you're not audible.
Yes. Very nicely you explain everything.
Thank you, sir.
And सबसे इम्पोर्टेंट है कि जो आपने बताया ना, ये बहुत कम लोग जानते हैं. वो खाली कॉपी पेस्ट करने की कोशिश करते हैं हेड नोट्स को, लेकिन इसके इश्यूज क्या है, रेशो टिसेंडी इसका क्या है, ये सब अगर प्रॉपरली डालते हैं ना, तो सही में ये बंदा वैल्यू एडिशन करने वाला है सुप्रीम कोर्ट में. सो एग्जामिनर कैन थिंक इन दैट वे. तो दिस इज अ स्कोरिंग सब्जेक्ट ऑल्सो. बट मैं एक चीज ऐड करना चाहूंगा कि व्हेन यू आर राइटिंग द पेपर, don't read each and every line and then write from the head notes. When you flag the 5 different head notes cases from head notes, then when you write the questions, use the only head points of head notes, and you explain that particular point in your own language, so that time you can cover your paper in time. इसलिए हेड नोट का मदद खाली जस्ट टचिंग के लिए ही लीजिए. ऐसा पूरा डिटेल में देख के एक लाइन लिखेंगे ना, तो आप कुछ बंदे 2 क्वेश्चन भी कवर नहीं कर पाते 3 घंटे में. फर्स्ट टाइम में उनका ऐसा ही होता है. बट यू डेलीगेट द टाइमिंग. जैसा आधा घंटा है, आप एक काम करो, आधा घंटा एक क्वेश्चन को दो, तो 5 क्वेश्चन के लिए कितना हो गया, 2.5 आवर्स. आपके पास 3 घंटा है, तो आधा घंटा बचेगा. फिर आधे घंटे में आप वापस देखो 5 के 5 क्वेश्चंस को जो आपने लिखा है. वहां पे एग्जामिनर जो रहना है, हमारे जो एग्जामिनर है ना, वो सब सीनियर लॉयर है. सीनियर लॉयर एग्जामिन करते हैं. उनके पास उतना समय नहीं आपका पूरा डिटेल में लाइन टू लाइन पढ़ना. अगर आप आखिरी आधे घंटे में आपके 5 क्वेश्चंस को अगर हर जगह पे थोड़ा सा हाईलाइट करके देते हैं, उनको सेम इंक से करना है. सपोज ब्लू इंक से आप पेपर ले रहे हैं, तो ब्लू इंक से ही करना है. ब्लैक इंक से लेते हो तो ब्लैक इंक से ही एक कुछ वर्ड को अंडरलाइन करो, और थोड़ा सा हिसाब दिमाग में रखो, भाई ये क्वेश्चन को 20 मार्क है, तो कम से कम मैंने 20 या 25 वहां पे अंडरलाइन करके रखने चाहिए. तो क्योंकि एक पॉइंट बराबर आ गया तो वो मुझे 1 मार्क दे देगा. तो आउट ऑफ 100 आई शुड गेट 100 मार्क्स. दूसरे क्वेश्चन में सपोज दूसरे क्वेश्चन में ए और बी है, सपोज ए को 10 मार्क है, बी को 10 मार्क है, तो ए के जो आंसर है वहां पे 10 जगह पे किधर तो भी आपके अंडरलाइन चाहिए. बी में भी 10. ये थोड़ा सा ऐसा फिनिश करेंगे प्रॉपरली, और खुद के व्यूज डालो. और कभी कभी कोई जजमेंट, स्पेसिफिकली कोई जजमेंट में अगर वो पॉइंट क्लियर नहीं हुआ है, एडजुडिकेशन, इवन दो कॉन्स्टिट्यूशनल बेंच इज देयर, even though 7 judge bench is there, even though 9 judge bench is there, and highest bench in केशवानंद भारती 13 जज बेंच. और एज अ एडवोकेट आपको लगता है कि ये इश्यू ये केस लॉज में कंप्लीट नहीं हुआ है, इन दैट हियरिंग यू राइट दैट प्रॉपरली, राइट दैट एंड हाईलाइट दैट. एग्जामिनर को पता चलने दो कि आप जजेस को भी स्क्रूटनी करने की ताकत रखता है. वो पर्टिकुलर जजमेंट में वो इशू, ये इशू बाकी क्लियर हुए है लेकिन ये इशू क्लियर नहीं हुआ, ऐसा अगर आप क्लियर करेंगे और वो समझ में आ गया ना, डेफिनेटली वो आपको उठाएंगे एओआर के लिए और एओआर के पैनल में लाके खड़ा करेंगे. तो ये है. और खास बात मैं बताना चाहता हूं कि इसके ऊपर मैंने लगभग एक बुक भी है 64 केस लॉज का, लीडिंग केसेस का. इसमें मैंने हेड नोट से ही कुछ पार्ट जो है उसमें दिया है, तो वो बुक्स एक छोटा भी हो जाता है, हैंडी हो जाता है, हेड नोट की प्रैक्टिस भी हो जाती है आपकी पढ़ने की, और
अंत में यानी कि 2 दिन के बाद पेपर है आपका, 2 दिन पहले आपको देना है, तो खाली एक पहला पैराग्राफ भी हर एक केस का पढ़ लेंगे ना, तो आपको पता चल जाएगा कौन से केस में क्या है। तो ये अमेज़न पे, फ्लिपकार्ट पे मिलेगा। कृपा करके हमारे ऑफिस में फ़ोन मत करो, मुझे फ़ोन मत करो, मनोज को फ़ोन मत करो बुक्स के लिए, कि बिकॉज़ वी आर प्रैक्टिसिंग एंड फुल बिज़ी लॉयर इन सुप्रीम कोर्ट। पूरे भारत के लोगों की सेवा करने का भगवान श्री कृष्ण हमको मौका दे रहा है, इसलिए हम उसमें लगे हुए हैं। बुक्स बेचना ये हमारा काम नहीं है। बुक सेलर भी हमको फ़ोन करते हैं कि आपके बुक्स हमारे स्टॉल में रखो, लेकिन हम बुक सेलर नहीं है। हमारा पब्लिशर चेन्नई का है, उन्होंने सब पूरा अमेज़न पे, फ्लिपकार्ट के ऊपर, यूके में भी मिलता है हमारा, यूएसए में भी हमारे बुक्स मिलते हैं सभी। 60 more than 61 बुक्स ऑफ माइन आर देयर ऑन अमेज़न ऑन सुप्रीम कोर्ट केस लॉज। और स्पेसिफिकली यूट्यूब के ऊपर मैंने ये 64 के 64 केसेस का एक 4 वीडियो अलग-अलग करके बना के रखा है। उसका भी आप देख के उसका रिवीजन कर सकते हैं। और मैं खाली एओआर के लिए नहीं बोल रहा हूं, मैं पूरे भारत के सभी लॉयर को अपील करता हूं कि ये 64 केसेस अगर आप ठीक करेंगे तो आपका किसी भी कोर्ट का प्रैक्टिस बहुत इजी हो जाएगा। ये लीडिंग केस ही ऐसा है। ये लीडिंग केसेस क्यों है ये पढ़ने के बाद ही पता चलेगा। इसलिए खाली एग्जामिनेशन के लिए 64 लीडिंग केस से तैयार करना बिल्कुल नहीं, आपको करना है आपके करियर के लिए। बेस्ट लॉयर बनेंगे तो टॉप लॉयर बनेंगे। डोंट सी बी डायरेक्ट पोजीशन ऑन टॉप, बेस्ट का पहले एक्सेप्ट करो। व्हेन यू विल पुट योर होल all efforts ओके एंड विथ पीसफुल माइंड। मेन एडवोकेसी का क्या रहता है, जितना पीसफुल माइंड रहेगा। इसलिए स्पिरिचुअलिटी में मैं जाना चाहता हूं थोड़ी देर, कि स्पिरिचुअल लेवल पे अगर आपका ध्यान का करने का है, एक्सरसाइज करना है, ध्यान करना है, अगर ये आदत है तो आपका पीसफुल माइंड रहता है। जितना पीसफुल माइंड रहता है तो उतना, जब हमारे पास हाईकोर्ट का ऑर्डर आता है, मेरे कोर्सेज भी है, अलग अलग कोर्सेज भी, आप ऐप, हमारा जो जयप्रकाश सोमानी ऐप है, वो ऐप पे जाके कोर्सेज भी देख लीजिए। वो कोर्सेज भी कुछ लोग एक्सेस कर पाएंगे, प्री रिकॉर्डेड कोर्सेज है, क्योंकि हमको टाइम नहीं ऐसा लाइव लेते बैठने का। इसलिए बहुत दिनों के बाद मेरा नानी पालखीवाला नेशनल लॉ क्लब का प्रोग्राम हो रहा है, और यहाँ से आगे हम कोशिश करेंगे हर 15 दिन में कोई प्रोग्राम आपको दे। तो मुझे ये बोलना है दोस्तों कि पूरे भारत के जो भी लॉयर, कोई तहसील में काम करता है, कोई डिस्ट्रिक्ट में काम करता है, कोई हाई कोर्ट में और कोई सुप्रीम कोर्ट में, स्पेसिफिकली हाई कोर्ट लॉयर एंड सुप्रीम कोर्ट लॉयर विल बी हेल्पफुल बाय रीडिंग दिस 64 केसेस। 64 केसेस रीड करो, आपको पूरा कॉन्स्टिट्यूशनल वैल्यू जो है, फंडामेंटल राइट्स कहा के कैसे कैसे टर्न हुआ है, 21 आर्टिकल 21 कितना फ्लोरिश किया है सुप्रीम कोर्ट के अलग अलग जजमेंट से, उसको सुप्रीम कोर्ट के अलग अलग जजमेंट से कितना फ्लोरिश किया है। आर्टिकल 20 को, 21 को, आर्टिकल 14 तो है ही स्ट्रॉन्ग, आर्टिकल 19, ये हमारे फंडामेंटल राइट्स है दोस्तों। इसलिए लॉ स्टूडेंट अगर कोई ये प्रोग्राम देखता है तो लॉ स्टूडेंट को मैं बोलूंगा कि फर्स्ट, सेकंड, थर्ड लॉ या 5 इयर्स का कोर्स करते हैं, उसमें ही ये 64 केसेस कंप्लीट करो। सुप्रीम कोर्ट प्रोसीजर वगैरह जो है वो भी आप क्लियर करो। सुप्रीम कोर्ट प्रोसीजर के लिए आदित्य आने वाला था, लेट मी आस्क मनोज। उसके पहले मैं थोड़ा सा गुरप्रीत के साथ बात करता हूं। गुरप्रीत, हम नेक्स्ट वीक में सुप्रीम कोर्ट के कैंपस में मिलेंगे, लंच लेंगे साथ में, बराबर है? और जरूर मिलते रहना। और आपको आपके जर्नी में किधर भी हमारी हेल्प लगती है तो कभी भी फोन कर सकते हैं, कभी भी हमारे ऑफिस में आ सकती है, कभी भी चेंबर में भी आ सकती है। 312 चेंबर है हमारा, उसमें भी आ सकते हैं। रजनीश तो वहां पे बैठा रहता है, मैं तो चेंबर में ज्यादा बैठता नहीं। सुप्रीम कोर्ट का केस हियरिंग होने के बाद मैं मेन न्यू अशोक नगर ऑफिस में आ जाता हूँ, लेकिन कभी भी आना बोल सकते हैं तो हम मिलेंगे, बातें करेंगे। कभी किसी भी एओआर को कोई इश्यू रहता है, भाई ये मैटर ऐसा ऐसा आया है तो इसको कैसा टर्न करना, तो जितना भी भगवान श्री कृष्ण ने हमको थोड़ा बहुत अल्प बुद्धि दिया है, वो बुद्धि के हिसाब से हम आपको गाइड करने का कोशिश करेंगे। और मैं आपको यस, एंड आई विश यू कि आप काफी जो हमारे डायरेक्ट बार में से बेंच में एलिवेट हुए हैं, ऐसा आप भी फ्यूचर में एलिवेट हो, और आपके सामने आर्गुमेंट करने का, एज ए सुप्रीम कोर्ट जज आपके सामने आर्गुमेंट करने का एज ए लॉयर मुझे सौभाग्य मिला। और मेरिट पे केस मेरी डिसाइड करो पहली, जब जो भी मैं पहले आर्ग्यू करूंगा। मैं सोमानी सर है, इसलिए बिल्कुल डोंट गिव मी एनी favor, you can dismiss my case when there is no material in my argument. So ये मैं चाहूंगा, और अपने अपने जूनियर को जज के चेयर पे बैठते देखना, ये मेरा सपना ही सपना है। इसलिए मेरे पास जो भी जूनियर आते हैं सबको मैं मोटिवेट करते रहता हूँ कि भाई आप जज बनो, आप आगे जाओ, एज पर योर लाइक। आप एडवोकेट जनरल बनो, सॉलिसिटर जनरल बनो, एडवोकेट जनरल बनो, आप अटॉर्नी जनरल बनो, ऐसे अलग अलग पोजीशन पे जाइए। यू आर जस्ट यंग, यू आर डायनेमिक, और बहुत अच्छा आपका फ्यूचर रहे। बस आपको शुभकामनाएं देता हूँ।
I just want to touch upon the spirituality aspect जो आपने कहा। I am a firm believer of God, and although I am a follower of Sikh religion, but I believe in Krishna so much. तो मुझे लगता है कि जो आपने बोला ना कि spirituality is required, meditation is required, I always, don't give credit of passing my, exams in first attempt. AOR exam was the first attempt, and I cleared it in for one go. I give the credit to the blessings of the God and, Almighty. And I'm really thankful to you, sir, and your team for giving me this opportunity to come on this platform and share my views about the exams.
Thank you. Thank you.
Thank you so much, sir. Thank you. See you in Supreme Court, sir.
Yes, yes. और कृष्णा जी की बात बहुत अच्छी की है। कृष्णा जी तो हमारे दिल में ही रहते हैं। हम रोज ध्यान करते समय उनके पैर दबाते हैं, उनका बहुत अच्छा ध्यान करते हैं। उनके साथ कभी कभी हम गुरु के ग्रह के ऊपर जाते हैं, कभी कभी शुक्र के ऊपर जाते हैं, कभी कभी सूरज भगवान को भी देख के आता है। ध्यान में एक अलग शक्ति है, कल्पना शक्ति, ध्यान अलग शक्ति है, उससे एक अलग ऊर्जा मिलती है, एक अलग पीस मिलता है। बस थोड़ा 5-10 मिनट भी ध्यान करना शुरू करता है कोई ना, क्योंकि हमारे एडवोकेसी में बहुत जरूरत है। और जैसे जैसे आप सक्सेसफुल लॉयर होते हैं ना, पैसा ज्यादा कमाने लगते हैं ना, तब आपका थोड़ा पेशेंस डिस्टर्ब होने लगता है। इसलिए उस समय ध्यान की बहुत ज्यादा जरूरत है।
बहुत ज्यादा।
यस, वेरी गुड, वेरी नाइस।
थैंक यू सर।
चलो दोस्तों, अभी हम लास्ट पार्टिसिपेंट जो है हमारे AOR के अस्मिता मंडलिया आ गई ना मैडम, अस्मिता मैडम। सो अस्मिता मंडलिया मैडम को हम यहाँ पे इनवाइट करते हैं। एक मिनट, लेट मी। यस यस, अस्मिता मैम, you can unmute yourself. Can you unmute? Advocate Asmita? Ashima, sorry. Ashima Mandia. Welcome, Ashima ma'am. Let me tell the audience about your marks. Ashima Mandia got paper 1, practice and procedure of Supreme Court, 81 marks. Paper 2, drafting, 61 marks. Paper 3, professional ethics, she got 75 marks. And paper 4, leading cases, 88 marks. So this is a fantastic marks as per concerned AOR examination. And I will request Ashima ma'am to speak on practice and procedure, because I know that Manoj have given you the subject to speak on leading cases. But leading cases, we have 2 speakers today. So Gurpreet cover that. But you can speak on leading cases also. But along with the leading cases, you speak on practice and procedure also. So before that, you tell us your background, okay, and how you
get motivated to give this examination. Okay. And then you tell about your practice part of this examination altogether. And even though some points are repeated in from earlier speaker, if some point are repeated also, no issue about that, because we will publish this video as a full program also, and then we will publish this video in different fragmentation also on different subject, different. So we can share that videos also in Nani Palkhivala National Law Club official group 1 and 2. We will share that the videos also. So people will enjoy forever. So, Ashima ma'am, now mic is with you.
Thank you so much, sir. Good afternoon, everyone. Just a small correction. My name is Ashima Mandia.
Okay. Sorry for that.
No, please, sir.
Instead of Mandlia, Mandla is there. Yes.
Thank you so much, sir. And I'm very grateful to be given this opportunity to address such a prestigious club. Mr. Nani Palkhiwala's legacy continues for generations to come. And it's an absolute honor to be able to address an audience today and in a club which is named after him. So far as my background is concerned, I am a first generation lawyer. I have been the junior of Mr. KTS Tulsi. My primary practice is in criminal defense litigation, both white collar as well as blue collar. I've had my own firm for the last 6 years by the name of Mandla and Singh Law Chambers. The AOR exam I have cleared in my first attempt, and as much as with everybody else who's been speakers today, because we keep very hectic schedules. So even my preparation was only limited to about 25 to 30 days, not more than that. But given if you've primarily practiced in Supreme Court, these examinations would not be so difficult for you to pass in the first instance, given that the content and the syllabus of the papers is not very far from reality. It is something that you would anyway need as a part of your practice and procedure in the Supreme Court, given we have 4 papers. The first is, of course, practice and procedure, which is predominantly the Supreme Court rules, along with the Constitution of India, because Supreme Court gets all its powers from the Constitution of India, unless some specific acts also empower Supreme Court with statutory appeals. And then there is drafting, professional ethics, and leading case laws. So far as how my preparation has been, I took in some advice from my seniors who had cleared this exam in their first or a subsequent attempt. But the basic structure which I was told was, and I followed it, was that I am a believer of the fact that if we do not rely so much importance on the guidebooks or bookies, it will be much better for understanding the concepts if you actually go back to the bare reading of the material. So if I have to now talk about practice and procedure, there is one book, and that is of Mr. Venkataramani, who is our current Attorney General for India. His book is the book which is also being used by examiners, because we were recommended this in our lectures by the registry, which I held every year, a month before the examinations. So read it cover to cover. Your concept clarity will definitely enhance to a great extent with that. And coupled with the practice and procedure book, as well as the Supreme Court rules. Now, because Supreme Court has its own rules under the Supreme Court rules of 2013 is the latest edition that is there. And apart from that, there are some noted leading case laws which have to also be seen for this paper. One important thing that one must keep in mind is that even though leading case law seems to be a separate paper, but across these 4 papers, there are case laws. So this is something which was not very clear to many of us till the time we didn't sit for the registry held lectures. And it is only then we understood that the format is that no matter which paper you are giving, of course, you're talking about concepts in practice and procedure, but the concepts application would be through judicial precedents. Then when it comes to drafting, now what we were told by the examiners last year was that not only do we have to only restrict ourselves in the drafting paper to the bare format of how, see, we all know that in terms of the Supreme Court rules, there is only one format which is given in the rules itself, which is Form 28, that is for SLP. Apart from that, there is no one fixed format for any of the other drafts. But all the inferences have to be taken from the rules itself to structure our drafts. But even apart from that, we were told very categorically that we would, of course, fetch better marks on if the content is relevant in terms of the cases as well. So we were asked to be aware of the developments of the Supreme Court in latest judgments which took place over the last year, because the relevancy came in that when the questions came in on the drafting paper as well, if we were told that at least to have 2 questions of law, 4 grounds, and in those grounds, if you're able to cite some relevant judgments to that extent, it would fetch better marks. And then professional ethics, for one, there is, of course, the Advocates Act, the Bar Council of India rules. Apart from that, everything is, again, it's even professional ethics is heavy on the relevant cases. And that list is all of that is already there in the AOR section that you find on the Supreme Court website. And of course, the examiner and whoever would be conducting the registry lectures this year would also roll out some case laws for your perusal. And then, of course, leading case laws is the only one which has a certain number of 64 case laws which are given on the website. But apart from that, what we were advised last year was that also see the follow-ups of those relevant cases. Like, for example, there is the judgment on reservation of Indira Sani. And apart from that, we were asked that it would lead to better marks if you can also see the follow-ups in other reservation cases that have taken place, like the Maratha reservation judgment, which came out, which became the 103rd constitutional amendment. So this was just something as a matter of advice that came to us, that given I had prepared to speak on latest case laws, but now sir is requesting me to do practice and procedure. So if I'm allowed to share my screen, sir, I'll be able to show how the notes came about. So it will be a little more practice oriented and easier for people to prepare as well. For example, last year, we were given this slideshow, which is available on the Supreme Court website, of practice and procedure by Vibhadata Makhija ma'am. And the advice across all papers were that they are not looking for you to just fill up pages. Even if you are attempting a 20 marker in, say, 3 pages, but those 3 pages have to be content driven. If you're going to be just thinking that you will just fill in more number of pages and that will fetch higher marks. This was absolutely strictly advised against. It has to be crisp, to the point. You may write in bullet points, but it has to be relevant to what the question is seeking. So because it is easier for the examiner to also assess whether you actually understand the concept or you're just trying to fill pages. So what we were asked was, they of course divided the entire Constitution of India, the powers of the Supreme Court, right from Article 131, and it went up till Article 142, and the relevant judgments on that. So this was just a brief pointer-wise format that was given to us to, first of all, break down that particular article of the Constitution empowering the Supreme Court for conferring any kind of jurisdiction on it, the special features, if any, and then, of course, the judgments on that. Now, judgments, again, we were advised not to only write in a couple of lines, but ideally give an entire background of how that judgment came about. And the way you break down a judgment is always the facts, the obiter dicta, as well as the ratio descendi. All those components together would give you a holistic picture of what the judgment actually states. So this was, for example, and especially this is important because Kunya Ahmed, for example, for the last couple of years, there have been cases coming, questions coming exactly on Kunya Ahmed, to ask that if the you would approach under 136 to the Supreme Court against a review dismissal. And for example, in the Supreme Court, in the SLP against the review order, dismisses the SLP in limine, then can you go back to the High Court? And this is a question of law which has now again been sent up to the larger bench in the Supreme Court for the consideration at the moment. So same way, for all jurisdictions, this slideshow is easily available on the website. One may access it. It gives you a structure. You can read up more about it in the practice and procedure book, as well as you can actually just download the actual judgment and make your own notes. So for example, for everything that was mentioned in this slideshow, I made an endeavor to make my own case notes on each of the judgments so that it is crisp. You don't have to, because right before the exams, these are 4 papers that are going to be back to back. Now, we can't think about while we are sitting for the examinations to read something which the content of which is new. So it is preferable that you make your own notes at your time and pace in the manner in which you prefer making them. And it will be much easier for you to just have a bare revision of them. So these are the notes which I made in the end. My absolute advice to everybody is that please don't make an endeavor to make these notes by reading articles. It is when you are at the Supreme Court giving for this, sitting for these examinations, we are anyway at least 5 years into practice. And the content of these papers is something which I found to be absolutely very relevant in your day-to-day practice as well. After going through the entire material, and I say this with an absolute candidness, that I started applying the interrelated principles, which, these are judgments which you must have read in your college days. But sometimes you lose connect with it because you're reading them only perhaps for examination purposes. But if you actually make an endeavor to understand these judgments, they will enhance your set of skills and knowledge while practicing not only before the Supreme Court, but because across forums across. And it actually leads to you developing a better skill set for your research and even for your drafting. That substantially increases. So I feel the curriculum that has been laid out for the AOR examination is a must for every lawyer which is practicing before the Supreme Court, whether or not you have any aspirations to just be an advocate on record. And I believe that CGI, Mr. Chandrachud, he was very, very categorical when our induction took place, that AORs should not be reduced to mere signing authorities. And there is, of course, a duty that is casted upon an advocate on record to ensure that even if there is somebody else who's drafting and you are merely filing it, but one should just not become a signing authority. You must go through the entire draft and see whether it is actually in line with the statutory principles and in line with the judicial precedents as well. Because he mentioned that at the end of the day, it is your name on the file. So you have to have that sense of responsibility towards the court, because at the end you become officers of the court and you are held responsible for it. And there have been incidents in the recent past where the judges of the Honorable Supreme Court, they are pulling up advocates on record for not having this kind of due diligence and seeing what is being filed on their behalf. So this was actually very wise advice, because while you're embarking on this journey, you must understand the seriousness that it holds as well. So these are some, I just wanted to show that I made these kind of notes. It was far easier for me to recapitulate a day before the exam, just to go through those 30, 40 odd pages, and of course, written notes. See, to be very fair, for example, the slideshow that is given out, these are in mere pointers, but one will have to make their own notes as well to not only pass this examination, but to also take away those learnings and findings with you. Now, so far as Supreme Court practice and procedure is concerned, we are, of course, bound by the Supreme Court rules. And apart from that, you can also download this handbook on practice and procedure and office procedure, which is there on the Supreme Court's website. And this will also, as you can see, it has in absolute detail a lot the jurisdictions mentioned, because Supreme Court also has statutory appeals from at least 23 legislations, and questions do come in on that as well. And a lot of people get very confused about which will fall under original, appellate, or extraordinary jurisdiction. If you actually look at this PDF, which is available on the Supreme Court's website, it will give you a lot of clarity, because there are certain questions that are recurring across papers which say that enlist the different jurisdictions of the Supreme Court. So no better place than looking at the Supreme Court manual itself for this. So this came around much later. We were not informed about this in our lectures last year, but I just stumbled across this, and ever since then I've kept it in the office, even for filing purposes. It's of great help, because it tells you exactly what article to invoke when you're filing something. So it's a great referencer. It's a slightly lengthy PDF, but skim through it once, and this will be something that ideally, once you clear this examination, or even otherwise you are practicing in the Supreme Court, you should have it in your office, most definitely. Now, apart from this, so far as practice and procedure is concerned, the best way which I undertook from what worked for me was that I opened the Supreme Court rules and took it order by order, and took the book of practice and procedure by Mr. Venkataramani and this manual by the Supreme Court all together at once, and then made my summarized notes on each article along with the order corresponding to it. If you do it in this manner, it actually helps you prepare for two papers, because the drafting paper that you will attempt the very next day will also have this exact interplay of Supreme Court rules and practice and procedure. And why that is relevant is, if I just open Supreme Court rules for a moment and show it to you. Now, for example, we look at so from here, you start with appeals in general. Order 19 is civil appeals. But I just wanted to show you how it will help you in the drafting by looking at the writ section. Since I mentioned it a couple of minutes ago, that there is no fixed format in the Supreme Court so far as petitions are concerned, apart from SLP. Now, what declarations to write when you are drafting a writ petition or a PIL, all of that you will find exactly in here. Now, if you look at SLP, which has come in first, civil SLP is order 21, criminal is order 22. Now, if you do your drafting paper, you would see that when we say before the Honorable Supreme Court of India, special leave petition, civil or criminal as the case may be, and then we write under Article 136, read with order 21, if you are doing a civil SLP, and order 22 if you're doing a criminal SLP. And along with that, you will see a lot of AORs who also specifically mention that the form is 28, of course, and they say 2 or do subrule 2 order 21, because the rules are here. How exactly an SLP has to be filed? Say, for example, it says it has to be in the format of form number 28. Then you have to have chronological list of dates. Then the because as anybody who has done even one petition in Supreme Court knows that unlike the drafts that we do across district courts or high courts, where we are at liberty to mention the facts in the sequence as we wish to inform the court, in the Supreme Court, it has to be done chronologically. Otherwise, the registry will mark defects. And apart from that, there is, of course, there's no collie system. So that's why it says that it has to have, each of the date have to be separately furnished. So you will also see all documents shall be indexed separately. This is where you come to know that the annexures can never be collie in nature. So if you do Supreme Court rules, practice and procedure properly along with the Constitution, with the material in hand, you will be able to prepare actually not only for your Supreme Court rules paper, but for your drafting paper, at least for the formats. And then, of course, the content is something that you will have to put in yourself, and at least 5 years minimum being at the bar, that should not be any kind of hindrance to anybody.
Very nice. You nicely mentioned everything and how you can prepare in one study 2 papers. That is very nice idea.
Sir, because realistically, this is something which I encountered as well. And near closer to the exam, you will see people will start reaching out for that we need a draft for a writ petition, we need a draft for an election petition. To be very honest, apart from the SLP's draft, there is no other structured format that is there under the Supreme Court rules. There are some PDFs which are circulating for the last couple of years on handbooks on drafting, but all those drafts are mostly from the 1966 rules, which have been discontinued ever since the 2013 rules have come in. And ever since then, there is no one book which is covering all the drafts. So this, as a matter of practice and procedure, even we follow this every time we make our draft, that anything you need to know, whether a certificate needs to be there, certificate of an AOR is there, or that of a senior advocate is required, like that of in a curative petition, or any declaration in a PIL is required, everything is already mentioned in the Supreme Court rules. So one has to just read them and make your own drafts accordingly. And then, of course, you can check along with each other. And by then, Supreme Court is actually fairly flexible on a lot of drafts. for example, which is something is that if you file a transfer petition and you need to file you also want an ex parte stay. In SLP, you have a prayer of interim relief within the SLP format itself. So there is no separate IA that goes. But when you do a transfer petition or a civil appeal, then the practice on ground reality is divided. Some people file an IA for ex parte stay, and some people use the SLP format, modify it to that extent, and they include an interim prayer clause within the petition itself. Both are acceptable because the registry is not going to be marking defects on that in practice and reality. The only difference is that unless there are some specifications of rules which are given under the Supreme Court rules, then you must follow that. Apart from that, on smaller issues like these, it is fairly flexible. Like this came in last year as a question, and I'm transgressing to another paper, but it just struck me. So it came in the last year's paper, in the drafting paper, that you're filing a review against a judgment, and you are not a party before the Supreme Court. So in that case, a lot of people forgot to mention an IA for permission to file review.
Yes.
The way you have permission to file SLP.
Correct.
So it's the same way. If you're a de facto complainant in a matter and before the High Court you've not been a party, you can come to the Supreme Court. All these jurisdictions you'll understand when you're actually reading the practice and procedure paper, that even if you're not a party, you can still approach in an SLP. So how that would logically transgress into your drafting paper is that if you're filing an SLP, you've not been a party in the impugned proceedings. So in practicality, you will have to file an IA seeking permission to file an SLP. So if you actually think about it from a practical standpoint, you will learn so much about the Supreme Court functioning by just sitting and studying for these examinations, that it will give you a lot of clarity thereafter. The number of defects in your filings will reduce, and you'll also, it actually happened to me, sir, in reality. Right after this, somebody came to me for a transfer petition, and they asked me to be an AOR for their filing. So they gave me the draft. I had a look over it, and then I told them, I said, you're invoking the wrong article in this. Your sections are wrong, because then in transfer petition also there are categories. You have a transfer under 406 CRPC, you have a 25 CPC, and then you have a Article 139A of the Constitution of India. Now, all of that has to only be seen in light of what exact relief you are seeking. So even though the SCR says it combines the rules for Order 25 CPC and Article 139A together, but these are not to be mentioned together in the petition unless and until you fall in a combined category in this. So this was something, when you realize that if you actually understand that concept, in practicality, it will become so much better than to have the embarrassment of redoing your draft if the registry points it out, or better or far worse if you lose in court because you've invoked the wrong jurisdiction, and in the first instance the court says that this is not maintainable. How did you even invoke this? So if one has to see it from a practical standpoint, then I believe it's an absolute must that anybody who's practicing in Supreme Court should necessarily undertake the course material, if not sit for the examination.
Correct.
So
and that specific requirement of 1 year practice under the more than 10 years practicing AOR, that should be followed. If a person followed that, and if he goes to each and every sections of registry, each and every sections of codes, that time practically he will prepare. Otherwise, 50% student of AOR candidate, they are taking only that certificate from AOR for the sake of that procedure only. But if they spare their 1 year valuable in Supreme Court physically, that will give them more inputs.
So the greatest learning for this paper is actually the preparation that we've had by just being in courts. So even if you're not an AOR, you've worked with somebody or you've had your own matters, because I've been appearing before the Supreme Court right from my second year. The first year, not supposed to once you enroll, you're not actually supposed to be appearing before the Supreme Court as per the rules. But of course, you go and assist your senior in those matters. And we've made it as a matter of habit since the inception that even if you're engaging in AOR, we used to get the draft vetted from the AOR, but also go to every section ourselves to get the petition listed. And then you realize that if you actually want to do it, you can do the filing and the listing in the same day, and your matter can come in the next day as well, if you understand the procedure well enough. Because sometimes there are absolute necessary matters which required urgent consideration, whether it's an anticipatory bail or any kind of order where you need a urgent stay, for example, in a demolition matter. So you have people who are filing it in the morning at 10 o'clock when the counter opens. And by 4 o'clock, you have to get everything, your registration verification, you have to get your cabin clearance. And 4 o'clock, you mentioned before the listing registrar, your matter will appear on the next day. So if that training is actually undertaken, you will understand.
Yes, I think some network issue is with Ashima ma'am, but no issue. Program is on right track. So friends, I hope you understand all the glimpse and how to crack this examination of AOR. और मैं इसमें ऐड ऑन कुछ चीजें करना चाहूंगा प्रैक्टिस एंड प्रोसीजर में, जैसा ड्राफ्टिंग के बारे में बताया आशिमा मैम में कि इसका कोई ड्राफ्ट का है, तो हमने ये साल ड्राफ्टिंग का किताब निकाला है जिसमें ऑल टाइप ऑफ ड्राफ्ट वी कवर्ड. दैट बुक इज अवेलेबल ऑन फ्लिपकार्ट एंड Amazon. And just type there Jayprakash Somani book, then you will get all my books, 61 books, and you can search out from that AOR book for AOR examinations. But we don't have that practice and procedure book till now. We'll try to launch in this year or next year. But I would like to add few things on practice and procedure. Practice and procedure in this paper, you should be clear what are the duties and what are the contents of the chamber judge. What are the contents of the SLPs? What are the contents of the criminal SLP, civil SLP? Order 20, Order 21. Then what are the contents of the writ petition? Writ petition is of two types. One is a regular writ petition. Both types are covered under Article 32. But one is regular writ petition, another is a public interest litigation. In regular writ petition and in public interest litigation, in both also, you should have exhaust existing remedies. So such type of practical points, if you are considering from Supreme Court Rules 2013 and Supreme Court Practice and Procedure 2017, which Ashima ma'am mentioned you very well. She shown all this to you on screen also. So you can write your paper in timely. And while writing paper on practice and procedure, so everywhere you mention the article, mention the particular rule of the Supreme Court procedure, and try to mention some case laws also in your answer paper, and categorize your timetable according to the question paper. If you are solving 5 questions, if you have to solve 5 questions, then give half hour to each question. 2.5 hours it will clear. Then you will get half hour, and that last in half hour you can recheck your paper properly. You can highlight your main points so that examiner can give you better marks. So dosto, this is the AOR examination. This is a challenging also because aggregate you should get 60% marks, and your writing practice is not now there. So every day you should write 1 or 2 hours daily. So this is a main. And now, friends, now last is Bhaskar Aditya join us now. Let me call Bhaskar Aditya. Yes. Yes, Bhaskar.
Yes, sir. Very good afternoon, sir.
Yes. Welcome, Bhaskar. Let me tell the audience about your marks, and then I will give time to speak you regarding your preparation and regarding your and specifically focus on practice and procedure of Supreme Court. Okay. Audience, Bhaskar Aditya got very fantastic mark in AOR examination. He got in paper 1, practice and procedure of Supreme Court, 68 marks. Then paper 2, drafting, he got 64 marks. Then paper 3, professional ethics, he got 64 marks. Then paper 4, leading cases, he got 54 marks. Aggregate, he got more than 60% marks, and he cracked this examination. So congratulations, Bhaskar.
Thank you, sir. Thank you.
Become a AOR and to become a part of the apex court of our India.
Thank you, sir. Thank you.
Now you explain your background. Now you explain your background and your preparation, how you prepare, how you get motivated to give this AOR examination. Why are you keen to practice in Supreme Court? Okay, is short, and then elaborate your subject, that is practice and procedure, study systems. Some give the tips for the new coming candidates of the AOR examination. So now Mike is with you.
Okay. So the first thing is about my background. So, sir, my hometown is in Ranchi. I have graduated from KIT Law School, Bhubaneswar. And so then after completing law, I have started my career in Delhi only. And then from there I started with the trial court, because under whom whenever I have interned, even I have interned before senior advocate Mr. KTS Tulsi, he also suggested me you should always start with the trial court, then go to high court, and then practice at Supreme Court, because once your base becomes the strong, then at the appellate side you will do well. So my when I've started my practice, I always wanted my my original side to be strong. So, sir, this is the thing. Am I audible, sir?
Yes. Perfect.
Okay. So, sir, this is a short glimpse. And regarding preparation, so to be very honest, after 5 years in the practice, when you engage yourself as a 5 years in the practice, you are also loaded with the work. And moreover, I was also loaded with my office work, with my personal work, with everything. So it's always become a challenging for a candidate who is preparing for an exam, because he's no more appearing as a student. He's appearing as an advocate who is already loaded with the work. So the first thing is the time management, work, and then preparation. And second thing, which Ashima has also pointed out, and you have also pointed out, we are not in a habit of handwriting in the paper. We are always used to with the typing and everything. So this is the second challenge. So, sir, which I have what I did, I just given 2 months in my preparation. In these 2 months, and one more challenging part was that in these 2 months, my marriage was also there. Exam was just after the date of after 3 days of my marriage.
Congratulations.
So this was another challenge for me. So this is the thing. So what I used to do, after courts, I have given 3 hours in for the preparation. 3 hours daily for 2 months is sufficient. Apart from this, I used to follow the previous lectures of SCORA and SCORA and Supreme Court Board of Examiners, which is already in the YouTube and also in the website of the Supreme Court. So I have followed these things, and then the study material which everyone has referred for, like study material of Mr. Venkat Ramani. But what I did, I've crystallized those things in my notes. So the one thing which I was very particular about it, I made my own notes. There was no particular book. I just read the book, formed my notes. Then I used to refer only my notes. No study. I haven't done with the study material. So what I can do, if all the candidates are here, I can share my notes for practice and procedure because it's to the point notes. And in my experience, since to be very honest, I cracked AOR exam in my second attempt. So what I've experienced from first attempt to the second attempt, like we have to be very content driven rather than writing a very longish answers. It's better to be content driven. You write short answers, but it should be content driven rather than giving all longish answers and filling up pages and pages. I think the content driven answers will help you to score more marks, and also it will also help you to save your time and attempt all the questions. So the important formula to crack the AOR exam is also that you need to attempt all the questions because even the examiners in their lecture always say, whenever they start their lecture, they always mention it's my request to every candidate to attend all the questions, because this will help you to at least reach the cutoff in an easy way. But definitely exam is very tough, and we are not in a habit of doing handwriting thing. And moreover, in practice and procedure, we have to be very particular with the jurisdiction of the courts, and we have to be very to the point. And even in the drafting or even in the practice and procedure, sometimes in the question paper, you will see they don't give the full particular question. They will say what will be the appropriate remedy for it, or draft an appropriate petition for this. There we will get confused whether it's SLP or whether it's civil appeal or whether it's election petition. So we have to be very particular with the jurisdiction of the court, on what cases we have to file SLP, on what cases we have to file the appeals, on what cases we have to file the this other petitions. So that particular thing is very much needed to be in our mind, especially at the time of examination. And in order to save time in drafting paper, what I used to do, I have first I used to draw the formats. पहले formats मैं पूरी clear कर लेता था. I used to draw the formats in the answer sheet. Then I used to write the contents on it. By this, the time gets saved, and then you come to know, okay, in this particular question, I have to give this much answer. Okay, now time is not much more, so let me give this much answer. So that helps in the time management in the examination, sir.
Very nice idea. Very nice idea.
Yes, sir. So this is the thing, and sir, in practice and procedure, what I will say to all the candidates, that it is one of the most scoring paper. Although it's a theoretical paper, and it is the most important paper, and it is one of the most scoring paper.
Very nice. And Bhaskar, you find time, you attend this webinar. And,
sir, I seek apology for being delayed because I was hecked up with the conference with one of the senior advocate. I've informed Manoj sir about it, so that's why all small ruckus was there. So
I can understand. Can I appear for 2 papers only in 2 years? ऐसा सवाल है राखी का. So can you give an answer?
2 paper in 2 years? No, you have to appear for all the 4 papers.
Correct. वेरी नाइस. हाँ, लेकिन आपका क्लियर हो जाता है, 3 पेपर क्लियर हो जाता है, और 4th पेपर को अगर यानी कि एग्रीगेट 60% मार्क्स आ जाता है, लेकिन किसी एक पेपर में अगर आपको थोड़ा सा 50 के नीचे मार्क है, तो उतना एक पेपर आप आगे दे सकते हैं. ऐसा कुछ
पर 50 के नीचे अगर है तो एक पेपर दे सकते हैं, बट once it is below 40, then you have to give all the 4 papers.
हाँ, below 40, then you have to give all papers.
And so one more thing I would like to point out, because this I have one of the examiner has told me post AOR examination, especially in drafting paper, because when we read the question paper, they say draft an appropriate petition or draft an appropriate affidavit. So be particular with that appropriate affidavit or appropriate petition, because if you enter any wrong number or wrong rules, if examiner is negative, he's going to give 0. He's not going to give any marks. So this thing should be very, for any candidate, the drafting paper, these things, they should be very particular about it, because they say that it's not we are asking question. You should consider that as client is coming to you and they are coming with these questions. So you have to answer in an appropriate manner, as Supreme Court is the last ray of hope for any litigant.
Correct. And examiner board is always with concern. Is this a fellow, is this candidate will add some values in Supreme Court or not? If the answer is in such a way, language should be proper, not hi-fi English required there, but your English should be adequately good. Your handwriting should be very good. Handwriting should be good. Your expressions, your thought process should be very good. That time you can easily crack these examinations.
Yes. And sir, drafting means specifically in synopsis and specifically in grounds. Like we always make one mistake, we like which I did in first attempt, and that I learned from my first attempt. Never write because the High Court has committed this error. That is something which everyone knows, that High Court has committed the error. That's why you are here at Supreme Court. Correct. So you have to be very content driven, which I have said it in my lecture. It should be content driven.
Direct put a substantial question of law. Directly put law. Don't allegate on a High Court and
in my first attempt, I used to write lots of grounds, and I flunked that drafting paper. And in my second attempt, I just written 3 grounds in every question, not more than that. But it was content driven.
Very good. Yes. So this is the benefit of the direct candidate who clear this examination. When you listen from that candidate, so who clear this examination, that time you can get the practical ideas. Theoretical ideas may be different.
It's a very good measure, sir, because it's a very good measure that these seminars are being conducted. Really, it's really appreciable, sir.
Yes. And now I am switching over mic to Manoj for vote of thanks. Manoj. Yes, you can unmute yourself. Yes, done.
Yeah. That's a great session, and we have got a lot of insight about the exam, and especially how to manage the time and all the intricacies of the exams. And lastly, again, I thank to all the AORs who have participated and given such a lightful session. And we have a lot of takeaways from this particular session, and that will help us in our exam. Thank you very much at the last.
Thank you. Thank you very much. Bye.